Public bodies, such as schools and local authorities, make decisions every day, and those decisions can have an impact on children and families. Sometimes those decisions might be challengeable because there's been a failure of the local authority to observe or meet a statutory requirement, for example, a duty to consult or a duty to provide education. In those circumstances, the local authority's decision making or inaction can be challenged by a process called judicial review. Judicial review is a formal legal procedure, and it's advisable to seek advice should you feel that you have a claim. Judicial review in education cases could be used to challenge a number of different omissions by local authorities and by schools. These include things like failure to provide education, the failure to provide the special needs provision that's described in an education health and care plan, and a failure to consult over changes perhaps that a local authority proposes to make to its funding policies or its admissions to special school. All of these types of decisions are capable of being challenged by judicial review. We have significant experience challenging local authorities by using the judicial review process. And if it's something that you'd like to inquire about, then please arrange an initial consultation with us. Here is some information about judicial review that you may find useful should you wish to use it as a means to resolve your legal dispute. Firstly, judicial review is what they call a discretionary remedy, which means that it's up to the court to decide whether your case is strong enough to grant you use of it. This means that you first have to write what's called a pre-action letter to the local authority or to the educational setting, setting out your grounds of challenge. They would then have a period of time, usually 14 days, to respond and to set out the action that they propose to take in response. In most cases, that is sufficient to be able to reach a resolution because it will be obvious whether or not the local authority is in breach of its statutory duty. If there is a disagreement, what then happens is you can apply for permission to bring a claim directly in the High Court. That's an application that's done on the papers and is put before a High Court judge. The judge will consider whether the case that's pleaded, set out in the grounds of claim, are arguable. If the judge finds that they are, they will grant you permission to apply for judicial review, and the local authority will be directed to submit a response. Once the response is received, the court will then decide whether it's likely the claim can be resolved, and usually the parties will resolve the claim of their own volition by having discussions, because ultimately no party wants to incur the costs of judicial review. This is where often agreements are reached, and they are reflected in what's called a consent order, which both parties agree to. Normally, the losing party will pay the costs of the other to this point. If the case is not resolved, then what happens is a full hearing is scheduled in the High Court. Now, those are normally in-person hearings, but they can be remote, depending on the circumstances of the case. Where a full hearing is required, they usually take a full day, and the court will analyse each party's case and the submissions that are made. Sometimes witness evidence is used to support a party's arguments or the local authority's defence. And at the end, the judge will decide whether to grant a remedy. The type of remedies that the court can grant are things like an order compelling the local authority to take a particular course of action, for example, to reconsult, or to provide the provision that's not been provided in an EHC plan, or, for example, to provide education to a certain level. The local authority obviously has the discretion as to how it takes those steps, but it will have to adhere to the order that the court determines. If a case is concluded via a hearing and you're successful, then the local authority would have to pay your legal costs in full, or if not, those would be assessed by the judge. Judicial review is a complex legal process, and it's important to take advice if you feel that you have grounds for bringing a claim.